welcome back to Law and Crime. We're in Idaho, where defendant Daniel Howard has been on trial for first-degree murder and felony domestic battery charges in the alleged murder of his wife, Kendy Howard. Kendy died back in 2021 due to a gunshot wound to her head. Initially, the defendant told police that Kendy died by suicide due to their divorce. However, an investigation into the case led authorities to believe that was not the case. In the latest development, Howard was arrested Friday night at Spokane International Airport while on property bond. His bond agreements included an 11 p.m. curfew, as well as not being within 2 miles of an airport. On Monday afternoon, the judge addressed this issue when court began. Let's see how that occurred.
Good morning, Judge Bruce. We're starting up again in the state of Idaho versus Daniel Howard. I spoke with counsel from Chambers about a number of issues. Mr. Johnson, you did want to make a record regarding one. Go ahead.
Thank you, Your Honor. It's a defense request to poll the jury after the 3-day weekend. Obviously, the media has covered extensively this alleged flight of Mr. Howard, who was following an individual who was there at the time of the arrest, returning a rental car. He was allowed to go to Spokane. He was not allowed to go within 2 miles of the airport. He had no bags in the car. He had his ankle monitor on. He had no tickets. He was not even in the airport itself. He was at the rental car exchange. Because of the media coverage and because of the assumption that it was flight, and because of the excessive amount of coverage, particularly locally here, the defense is concerned that it could change the jury's view on the case. We will instruct not to. So this is a defense request to poll the jury.
Thank you. Response, Mr. Morris?
Thank you, Your Honor. I don't think the jury should be polled, at least not yet. As the court knows, at least once a day, commonly more than once a day, that the court admonishes and directs the jury not to begin deliberations, not to discuss the case, and to basically not follow or seek information from the news or media outlets. And there, up until this point, including up until now, that there's been no proof or indication or any reason for anybody to suspect that the jury has disregarded the court's orders. I think the court should be trusting of its orders. We live in a small world. The internet, social media, we're all connected. And there's been nothing from this jury to give anybody here any reason to suspect that they can't be fair and unbiased, even if they have seen something in the news. So I don't see a reason to break from what's been the normal flow of the trial. Thank you.
Thank you. Well, I did speak with counsel in Chambers about this, and as I indicated in Chambers, I'm not inclined to poll the jury at this time. I have instructed this jury daily not to discuss this case with anyone else. I've instructed them specifically, particularly before the start of the weekend, to avoid news coverage, to not view any news coverage. And I trust that my instructions and orders to the jury are being followed. I believe, just from my experience over the last couple of weeks, I think nearly every day there has been a news story or coverage of this case online, in newspapers, YouTube, on TV. So news media coverage has been extensive, which is why I advise this jury to avoid any news sources. And I trust that following the court's instructions, this jury is a particularly attentive and conscientious jury. It was, I believe, the first day of trial or the second day of trial that we lost a juror, excluded a juror after having had some contact with one of the attorneys. And I think that impressed upon this jury the significance of following the court's rules. In fact, on a couple minor occasions, witnesses have once when a juror had some recognition of a witness, another when a juror had some business affiliation with a company that was referenced, brought that to bailiff's attention to address those issues with the jury. There was no concern. There was no inappropriate connection. But even in these minute, unrelated areas, the jurors brought it to the bailiff's attention, to bring it to the court's attention. I say that because I just know this is a jury that has been very conscientious about following the court's orders and remaining impartial. And so I spoke with my bailiff this morning. He indicated nobody has made any references to him or made any comments about anything. And I don't see a need to now hold the jury because there was coverage this weekend. I mean, there's been coverage last weekend as well of this trial. There's been extensive coverage of the trial, and I'm confident that the jury has followed the court's instructions and is fulfilling their duties as they ought. So I'm not going to go into hold on this. But we did want to make a record. So Mr. Johnson, the record has been made for service. Thank you. Anything else before we bring in the jury?
All right, the judge decided there he is not going to poll that jury, and we still have with us, obviously, attorney Paul Townsend and trial attorney and federal litigator Robin Nunn. And I'm going to start with you, Paul. The judge said that he thinks the jury has been listening to his instructions, that the jury hasn't been listening to the media, that they should not be polled about whether or not they heard this information from the media, information being that the defendant was caught and apprehended at the airport. My question to you is that going to get into the trial evidentially? Is the prosecution going to be able to say at all that this was sort of the, he's admitting that he's guilty. He's trying to run away, consciousness of guilt. We know that sometimes the actions of a defendant, it does get into court subsequent to the crime. They're trying to get away. Do you think that the prosecution will be able to get this admitted in front of that jury? They didn't listen, hopefully, to the media, but maybe that can get into the trial. What are your thoughts on that?
So it's possible, because that's the key phrase you mentioned, consciousness of guilt. If the prosecution can convince the judge that this is relevant and probative of whether or not he is guilty of the crime for which he is charged, then it becomes potentially admissible, subject to whether or not it is unfairly prejudicial. In this case, if this is consciousness of guilt, if the judge decides that the prosecutor can elicit this because it goes to the defendant's mental state, it shows that he has a guilty mind based on what he did, then it's very possible the prosecutor will be allowed to bring it in. This is the type of thing, this is the type of scenario that I would expect before the prosecution can just start putting witnesses on. There'd have to be some kind of hearing where this whole factual circumstance is fully explored by the judge and a determination by him about whether or not this is actually consciousness of guilt. Because you heard the defense attorney ramble off some rental car return story, which, if accepted, would show that this was not consciousness of guilt. So I think the judge would have to really explore this, make a determination as to whether or not it would come in that vein. But certainly it's not something that I think you could just start putting witnesses on and bringing out testimony about.
Exactly. Paul, you mentioned exactly what I wanted to ask Robin. We heard the defense attorney talking about, look, He was returning a rental car. Yes, he's not supposed to be within a certain mileage of the airport, but he was wearing his monitor. There were no bags in the case. It does seem to me that the judge will have to ultimately determine whether or not this evidence gets into the trial itself. What are the chances that it will, in your opinion, based on a little bit of argument that we heard there?
Yeah, I mean, I think that the basis that the defense counsel gave is plausible. We've all taken out rental cars and we've all had to return them to the airport. Sometimes that's the closest location. So the information that was provided makes sense in theory. Whether it actually is true and will win the day is time will tell. But I do think that the judge is going to have to take a look at this explanation and see if it has, appropriate grounds to be accepted, and they can move on from this and it not have any influence on this trial. If it isn't accepted, I think it could be very damning for the defense here. He is out. He on his own recognizance, and if he is indeed trying to flee, that would be a pretty strong bullet against his case of not guilty.
I agree 100%. Look, you were lucky enough to get a bond. You're out. Have someone else return the car if there's a rental car. And also, did he have a ticket? We'll see whether or not. We'll see what the judge decides there.